Hi everyone, welcome back to our channel. For today's video, we're going to look at the basics of applying for probate. There's a lot to learn about probate, so we're going to stick to the basics and take a closer, more in-depth look at each of the documents in another video. Let's get started with the basics of applying for probate. Let's get started with some definitions. Probate is a court process that validates the will. The original will, along with a bundle of other documents, is filed at the court for review by a judge. If everything is completed properly, the judge will sign an order granting probate. In some jurisdictions, this is referred to as a grant of probate, while other jurisdictions call it letters of probate. The testator is the person whose will it is. Throughout the application, the documents refer to the applicant. This is the person applying for probate of the testator's will. The executor is the person named in the will to handle the estate. This includes paying debts, collecting assets, and distributing the estate to the beneficiaries, who are the people named to receive something in the testator's will. Only the named executor can apply for probate. Often people think that because they're the deceased person's next of kin, they automatically have a right to apply for probate. However, unless the executor also happens to be the next of kin, this relationship is irrelevant. But what happens when the executor doesn't want to take on the job? In this case, if there's an alternate executor named in the will, he or she would be able to apply. The executor named first would need to formally renounce the role in order for the alternate executor to be able to apply. When there's an issue with the will that may impact its validity, or if there is no executor named, the probate application becomes an application for administration with will annexed. This is most common with homemade wills. For more information about this kind of application, check out our video, Probate versus Administration, Which One Do I Need? The executor can either complete the application for probate by themselves or hire a lawyer to do the application. Completing it without a lawyer is not a great idea if the estate is complex. As we mentioned, the probate application is comprised of a bundle of documents. The vast majority of probate applications are completed on paper, and it's uncommon for someone to have to appear in court. These documents make up the basis of the application. Different jurisdictions may require additional documents, such as a notice to beneficiaries. The first document that gets filed is the notice of application. This tells the court the basics of the application, such as who has passed away, who's applying, and what kind of order is being sought. The petition gives the court the details of the application and lists the beneficiaries. We'll look at the inventory more closely, since this is the part of the application that usually trips up executors. The application also includes an oath and an affidavit. The applicant swears the petition to be true and promises to do the job to the best of his or her ability. The applicant also swears to follow the law when distributing the estate. One of the most important pieces of the application is the original will. The judge reviews the will, and the court will retain the original once the application is complete. Along with the will, a proof of will is filed. This document is signed by one of the witnesses to the will and states that the witness saw the testator sign the will, and that the witness believes the testator had his or her mental capacity at the time the will was signed. Lastly, a draft order is included. This is the document that the judge signs to grant the probate order. The inventory is an important piece of the puzzle because it creates a court record of the assets that the executor is responsible for. This is also the amount the court uses to calculate the amount of the probate application fee. The fee is different in each province. The inventory is meant to be a snapshot of everything the deceased person owned at the time they passed away. Assets are grouped into categories to help form a summary of the estate value. As always, the form itself varies from one jurisdiction to another, but the general idea is the same across Canada. Common categories include real estate, motor vehicles, life insurance payable to the estate, and bank accounts. Along with the list, the executor needs to include the fair market value of each item. Some jurisdictions also require a list of liabilities and the corresponding value. Most often, this means a mortgage or a loan. So where do the values on the inventory come from? The values on the inventory are either provided by the executor or found through research. Sometimes the testator's bank is willing to provide a balance summary to the executor, but this isn't always possible. In many cases, the executor needs to look through the testator's home to find information about assets. This can include bank statements, receipts for large items, deeds to property, or appraisals for items like jewelry. When this information can't be found, the executor may need to contact other agencies, such as the municipality where the testator lived. The city can provide a municipal property assessment with an estimate for the value of the property. Other helpful resources include looking up the Blue Book value for a vehicle and searching the provincial land registry for titles. Often, executors will also contact professional appraisers for collections of items or a real estate agent to complete a walkthrough of the home. Now that all of this information has been collected, it's added to the court application. Some of the documents are sworn, either with a commissioner for oaths or a notary public, and filed at the court. The court fee is due at the time the application is filed and must be included with the application. How long it takes for the court to process and approve the order depends on the jurisdiction. Larger jurisdictions tend to take longer, simply because there are more people using the court system. Once the application is approved, the court will send the original order either to the executor or to the lawyer, whoever sent in the application. The court keeps the original will, so it won't be returned with the order. Once probate is completed, the applicant can act on behalf of the estate. Because probate is a court order, it gives the executor the legal authority to handle someone else's assets. This order also indemnifies the various institutions the executor will need to deal with, like banks and land registries. Normally, these institutions won't release information, much less the actual assets, to someone who doesn't own them. The probate order means that these institutions can divulge information and give the assets to the executor without being held responsible later. Where to find us? Visit our website, butlerwillsandestates.com, or check out our blog, estatelawcanada.blogspot.ca, or contact us directly at chelsea@butlerwillsandestates.com. If you like this video, make sure to click the like button, and if you want to see more videos about a variety of estate law topics, make sure to click the subscribe button. Thanks for watching, and we'll see you at our next video.